Welcome back. I think the discussion this morning is really quite fruitful, and this afternoon we're moving to kind of wider implications of Ukraine crisis, and the title includes refugee issues, food security issues, as well as climate and energy implications. Each of our speakers had a little bit of a different focus on these issues, and they will speak one after the other. I hope that we will be able to kind of bring the threads together afterwards. Our first speaker is a friend, not only of mine personally, but also, I think, a friend institutionally. And Dr. Ruvi Ziegler is an associate professor at the University of Reading. He has written widely on refugee law and policy issues. He has also written a book about the voting rights of refugees. He is a politician to some degree with the Liberal Democratic Party in the UK, and he is active on LGBT plus rights issues on campus and more widely. I'm really happy that you're with us today. Thanks for coming.
Thanks very much, and thanks for inviting me to this great conference. I'm really enjoying it thus far, and I hope everyone can hear me. So I've titled this talk, Displacement from Ukraine, Rediscovering European Solidarity with a question mark. And the question mark isn't so much about European solidarity in relation to displacement from Ukraine, but in relation to the rediscovering it and to the extent to which we can draw lessons from the treatment, favorable as you were, positive treatment of those who were displaced from Ukraine to the rest of the European continent for other crises, past and perhaps future, where European solidarity may be in shorter supply. So I think the ambassador has already mentioned some numbers. So I just want to start with those quite striking numbers. So there are 7.3 million refugees from Ukraine, says the UNHCR. They use the term refugees, and I'll come back to the terminology in a bit. But I would, at this stage, say people who were displaced, externally displaced from Ukraine to other countries. In addition to that, about 7 million people are recorded by UNHCR as having been displaced internally within Ukraine. This is already a higher number than the people who were displaced from and within Syria, which was the previous largest displacement conflict we have seen. So this dwarfs anything that we saw in Europe, but as I say, actually anything that we saw globally in sort of recorded memory. And that really is a striking thing to start with. And those people, despite the very large numbers, have been receiving protection in other European countries. And so the first question for us is to kind of analyze is what sort of protection they receive. Do they receive protection as quote unquote refugees? Is this the label that is being granted to them? And to discuss that, our starting point has to be the international framework in relation to refugees, which is the 1951 Refugee Convention. So Article 182 of this convention defines a refugee as someone who's outside their country of nationality, and they are outside that country because they have a well-founded fear of persecution for one of 5 convention-listed reasons: race, religion, nationality, membership of a particular social group, or political opinion. But the key element for the purposes of displacement from conflict, and in particular conflict between states, is actually the last condition in the refugee definition, which is that someone has to be unable or unwilling to avail themselves of the protection of their own state. The assumption under international refugee law is that the reason you are receiving protection elsewhere as a refugee under the convention is that your own state is either persecuting you or unable or unwilling to prevent you from being persecuted by others. You will note this provision says nothing about armed conflict, either as a necessary or as a sufficient eligibility criterion for receiving protection. So what does that mean when we think about people being displaced from conflict? Do they meet this definition or not? So the United Nations High Commissioner for Refugees handbook, famously or infamously, says that persons compelled to leave their country of origin as a result of international or national, it probably meant non-international, armed conflict, are not normally considered refugees under the 51 Convention or 67 Protocol. So the UNHCR position was that in conflicts, in classic conflicts, in fact, conflicts that have become far less classic, the conflict in Syria or in Afghanistan or in Somalia or in the DRC, etc., are conflicts of a different nature to this more, hop back to the early 20th century kind of war between two sovereign countries. That in wars between two sovereign countries, people will not ordinarily be refugees. Now, there was a lot of pushback against the UNHCR position. And so the UNHCR itself in 2016 published guidelines on international protection where it seemed to have done a 180-degree turn. In that document, it says that rarely are modern-day situations of armed conflict as violence characterized by violence that is not in one way or another aimed at particular populations or which doesn't have disproportionate effect on particular population, and that is what creates the causal link to one of the Refugee Convention grounds. And I think when UNHCR wrote this in 2016, and I partly know this from speaking to people who were involved in writing this, they thought about conflicts like Syria. They said, well, in situations like Yazidi women being persecuted by Islamic State, it's obvious that there is a specific group that is being targeted within the context of a conflict, but it's targeted on the basis of a convention-related reason. But there still remains a question as to situations like the one in Ukraine where you do have an interstate conflict. And in an interstate conflict, where with looking at areas in Ukraine that are controlled by Russian forces, then those who refuse to return to those areas, I think, can in earnest avail themselves of the Refugee Convention, because it is clear that Ukraine is unable to protect them in those areas because it no longer holds control over them. And it's also clear that the Russian forces, for unfortunate reasons, are not going to offer them the sort of protection they need. But what happens for the vast majority of people who have left Ukraine, who have left it from elsewhere in Ukraine, areas that are controlled by Ukraine? And I think there is a strong argument, actually, that they haven't really severed their ties to the country of nationality. Itamar has spoken earlier about the fact that Ukraine prevented men from leaving Ukraine or military age, but it hasn't prevented women and children. But it's hardly the case that the women and children who have left because they decided to sever their ties with the Ukrainian state. They may argue that Ukraine is unable to protect them, but it's not unable to protect them for a reason that is linked to their own characteristics. That is one of the 5 Refugee Convention grounds. And I think that is why, when it came to the European Union at the start of this conflict, even though most of the countries bordering Ukraine are EU member states, so the main refugee recipient countries, Poland, Hungary, Slovakia, and Romania, are EU member states. And as EU member states, they are committed not just to the Refugee Convention, which are all signatories to individually, but also under the European Union structures of refugee protection. They also are committed to another form of protection called subsidiary protection. Even though they have a framework that can be applied to individual refugees, there was a challenge. There was a challenge that arises in this sort of conflict of whether the framework for individual assessment of refugee application is a suitable one to apply when you've got millions of people crossing the border. And the reality then that the European Union found itself in is the reality that in fact existed for 20 years. So for 20 years, the European Union had on the shelf or in the drawer or in whatever other metaphor you wish to use, a temporary protection directive. It had a directive that was precisely intended for situations where individual assessment is neither practical, not necessarily desirable, but where a lot of people are coming at a short period of time from one area and need protection and hopefully one that is temporary. Alas, that directive has never been activated. Not a single time in those 20 years, including in the so-called refugee crisis of those arriving primarily from Turkey, but previously from Syria into Turkey, into the European Union in the summer of 2015. There was resistance to the application of the Temporary Protection Directive within the European Union framework, and so it was not applied. It was not applied in the Libyan war in 2011, but on this occasion, within 10 days from the start of the conflict, the European Union Council acted on a proposal from the Commission, and it unanimously agreed. Unanimously. This is a very critical point within the European Union structure to activate this Temporary Protection Directive for the first time. And the definition under this directive is that this is done as in response to the arrival in the EU of a large number of displaced persons who come from a specific country or geographical area, whether their arrival is spontaneous or aided. And that is, as you were, a perfect match to the situation of those arriving from Ukraine. And the right to temporary protection, this is one of the critical distinctions between that and the situations faced by asylum seekers, who, even though one should consider to be presumptive refugees, are not seen that way by states. They are seen as suspects who may be trying to abuse the asylum system. And so there's often a very big gap between what asylum seekers receive during the asylum application and after they receive protection. Here, the grant of temporary protection was immediate. In a sense, was a form of declaratory announcement in respect of everyone who met the definition. So it's an extraordinary operation. And as you saw in the UNHCR data, 4 million people are now registered in the European Union as enjoying temporary protection. So who's eligible for temporary protection? And again, this is the stark contrast to something like the refugee definition, which is almost inherently restrictive. Here, the definition applies to Ukrainian nationals who reside in Ukraine prior to the 24th of February and then were displaced following the military invasion, but also, strikingly, to those who are third country nationals or stateless people who were residing in Ukraine and unable or unwilling to return to their country of origin in safe and durable conditions because of the situation in that country. So when the Temporary Protection Directive was activated, almost inadvertently, and I wonder who are the new lawyers who kind of made the council agree to this, they have, in the back door, as you were, allowed an Afghani refugee who ended up in Ukraine, hoping to get to the continent, to the European Union, to receive temporary protection because they are displaced now from Ukraine. And this is only a short few months after there were scenes, quite harrowing scenes, in fact, of border police, both in Poland and in Lithuania, pushing away people who were trying to flee Belarus, who were originally from Iraq and Afghanistan. So not only was the Temporary Protection Directive extended essentially to any Ukrainian who crossed the border, it was also extended to third country nationals, to non-Ukrainian who were crossing from Ukraine. So an extraordinary framework. And not only that, the Temporary Protection Directive doesn't say that whoever is granted this protection cannot in future be considered a 51 Convention refugee. What it does, it, in a sense, presses the pause button on that question. It says this protection is granted you notwithstanding the potential that you will in future be assessed under the 51 Convention, and I'll come, if time permits, to what may be such circumstances. But in the meantime, that's not necessary. And in fact, as a result, under this directive, the member states are permitted to delay the consideration of an application for refugee status until that temporary protection status is ended. So in a sense, it's saying we're now under a different legal regime and the questions around the Refugee Convention will be paused. But the fact that they are paused, the fact that there is no assessment under the Refugee Convention does not mean that the rights that are granted under temporary protection are any lesser than the rights under the Convention.
So fundamentally, the only substantive difference between temporary protection and a formal refugee status is on the temporal dimension, is on the question of whether there is any prospect of somebody remaining long-term, potentially ultimately naturalizing, becoming a citizen. And that perhaps is inherent in the name, temporary protection. So if one looks at what people who receive temporary protection in the European Union are entitled to, they're entitled to access to health, to education, to welfare, immediately to work. Asylum seekers in most European countries have to wait 3 or 6 or even 9 months until they have access to the job market. In the UK, longer than that. UK no longer being subject to the EU directives and housing. But it's far beyond just a principle of non-refoulement. It's far beyond the policy, which in fact was the policy announced in Israel on the 27th of February, where there was an announcement saying anyone who's here, whose visa is going to expire, we will not enact any enforcement action against you, we will not deport you. But that wasn't coupled with, and hence, given you now have to be here, you will have access to health, education, welfare, work, etc. So those things didn't tag on to that non-refoulement, which is important, but not sufficient criterion. In the European Union, that has been part and parcel of temporary protection. And I think then, importantly, and this is where I get to the point around solidarity, what the temporary protection does very differently than ordinary times in European Union refugee law is that the point of the temporary protection directive is that the measures there are supposed to lead to what the European Union calls a balance of efforts between the member states, and that's code for responsibility sharing. Now, how does that get implemented? It gets implemented by the fact that under this directive, actually a Ukrainian crossing into the European Union, one of the EU's external borders, can choose which European Union member state they want to claim temporary protection in. They do not have to claim it in the first country to which they've entered. In fact, the European Union in the Council decision says this is a good thing because it means people can join family, can join their communities that exist elsewhere. All of these rationale that we refugee lawyers believe are very sensible. And this will ultimately ease the pressure on national reception system. Now, why do I say this is such a stark contrast to what ordinary matters look like? Because the only way in which the European Union operates, when it has spontaneous arrivals of people, including, as I said, just before the war, somebody who would have crossed into the European Union on the same border crossing, coming originally from Afghanistan following the shameful kind of departure or motive of departure of the West from that country and the crisis that ensued. If somebody had crossed that border into, say, Slovakia or into Poland, they would have to be processed by that country under the Dublin system. The Dublin system, the Dublin regulation, requires the first country of entry into the European Union to be the one that assesses your asylum application, which allows also, as a result, other countries, if you continue your path in the European Union, to return you, or to ask at least for that country to receive you back into its territory, so-called Dublin returns. And there are some exceptions for family reunification and unaccompanied minors and the like, but in the main, that is the framework that operates. So the general framework in European Union law is one of counter-responsibility sharing. Is one where the idea is that actually the frontier states, those that are in the south of Europe and in the east of Europe, not unsurprisingly those in the northwest of Europe, are the ones that are supposed to be dealing with asylum seekers and refugees. There were 2 attempts to try to change this. One, temporary, the relocation scheme following the 2015 summer, where the European Union tried to have people relocated from Greece and Italy. That was opposed vociferously by the Visegrad group, by Poland, Hungary, Czechia, and Slovakia. Note the difference from unanimity this time. And the second, the Commission proposal to have a regulation that would have a much better modality of responsibility sharing, which is currently stalled because lots of countries, in fact, are opposing it. So I want to, in the final 2 or 3 minutes, kind of turn to now, what happens when temporary protection lapses, and also what can we deduce from that different treatment also of Ukrainians? What can be the reasons? So the first thing is, as I mentioned earlier, temporary protection is intended to be temporary. There is actually a maximum ceiling of 3 years in the Temporary Protection Directive. It cannot be extended beyond that. Initially, it only operates for a year. I imagine it will get extended unless the war ends by February next year. But at that point in time, there may be quite a lot of people who will not be able to return to Ukraine, and they then may need to be assessed under Refugee Convention definitions or under subsidiary protection. So in that sense, it is a very helpful, very actually encouraging temporary solution, but it isn't the one for people who have now been uprooted and may in fact be able technically to return to their homes, except that their homes may no longer exist, right? Because their cities may have been shattered or obliterated by the Russian bombing. So what distinguishes this war in Ukraine? So as I said, the EU has activated this Temporary Protection Directive for the first time in this crisis. And I think that justifiably, triggered both praise for being decisive, being quick, 10 days after the start of the conflict, and acting unanimously, which has forced both politically, but I think also substantively. But I think the criticism is equally justified, if not more, of the fact that it was not doing a similar thing in previous crises. It is not showing a willingness to do similar things. And in fact, it is engaged in ongoing externalization policies, the attempt of which is to push away people who are not from Europe, who are from Asia, who are from Africa, and who are from the Middle East from coming to the European Union. So there can be reasons that I'm sure we can all think about, but I will not express of what perhaps differentiates people who come from Ukraine and people who come from Iraq, Afghanistan, Somalia, Syria, and the like. But I want to talk about the legal thing that distinguishes them. And the legal thing that distinguishes them and that the European Union policymakers were well aware of on the 24th of February relates to visas. So the critical legal distinction is that on the 24th of February, Ukrainians had already enjoyed visa-free access to EU member states. In other words, any Ukrainian could have crossed an EU border as a tourist legally and would not have had to apply for a visa in order to come. And that is entirely different for somebody from Syria, Iraq, Afghanistan, Eritrea, somebody from all of the countries that are major refugee-producing countries. And the reality is that the mechanism by which countries, particularly in the global north, are preventing asylum seekers from accessing their territories is through the introduction of visa restrictions and then the non-issuance of visas for nationals of countries that are likely to seek asylum. And I will only give you one example to finish off with, and that is the number of countries in the world to which a Syrian could enter without a pre-acquired visa. So either with visa on arrival or with visa waiver. That number was in 2010, 120, the date's 28. So with that in mind, I'll leave you with that sign, which was shown in a demonstration in London early on in the conference. Thank you very much.